Good afternoon, everyone. Allison Scalberg here, Consolidated Planning Group. We are happy to be here with you today. Thank you for taking the time to join us. We have a powerhouse today of awesome presenters, awesome in their field of what they do. And we're going to be talking today about the intersection of guardianship and family law when it comes to a loved one with a disability or special needs. So we're going to be taking a deeper dive into that. I always like to start by going over a few housekeeping items. Today, we are in webinar mode, and what that means for everybody is we can't see you or hear you, but we know you're out there, and we're glad that you're here today. Everyone that has registered for today's webinar is going to get a copy of today's slides and a link to the recording following the webinar. You'll get that via email. Sometimes it goes to spam, so you might want to check your spam on that. So I always like to mention that. So today, we have many slides. So what we chose to do is to include the slides. We are not going to get through all of them, but we're going to touch the treetops on the topics that are within those slides, but we left the slides in there for you for your reference as you go back and you look at this. So we did that on purpose. We knew we weren't going to be able to get through those slides today. So we just want you to know that. If you wrote a question in, if you submitted a question ahead of time, we have your questions. We are going to get to as many questions as we can during the time that we have together, and we do take questions throughout the presentation. If you have sent your question in, you do not need to resubmit that question in the chat box. We definitely do have those questions. If your question didn't get answered, we will reach out to you personally on that. And if the question is unrelated to today's topic, then that's kind of a one-off thing as well. So having said that, I just want to share a little bit more about Consolidated Planning Group. For those of you that have attended in the past, thank you for attending. We're glad that you're back. For those of you that are here for the very first time, Consolidated Planning Group is a holistic special needs financial planning firm, chartered special needs consultant, nationally certified as Social Security advisors, members of the Special Needs Planning Academy. Our whole firm is nuanced and helping you plan for a loved one with a disability, answering questions like who's going to care for my child when I'm gone, how much do I need to fund a special needs trust, what are public benefits that might be available to my loved one, how do we qualify for those and stay qualified for those. We help with answers to those questions. So the team that we have here today, we all work independently. We don't work for each other or with each other. We collaborate often. But each one of the team members here has a little bit of a different practice and what they do serving in the special needs community. So in a moment, they're going to share a little bit more about who they are and who they serve and what they do. So having said that, what I want to do, I do want to just turn that over to you three. Welcome, Trey, Mary Ann, Dr. Natalie. Thank you for being here today. This is a new topic for us and a good one. I mean, we've talked about guardianship, we've talked about family law and divorce with special needs, but this is a bit of a new topic today, so we're happy to do that. So Trey, over to you.
Yeah, thank you, Allison. It's an honor to be here. And I have learned that you're most talented when you surround yourself with talented people. And I'm just so honored that Mary Ann and Dr. Montfort would join us here in our presentation. My name is Trey Yates. I've been getting divorced every day of my life for over 41 years. I'm a little too old to learn anything else. Several years ago, I decided to retool my practice to have an emphasis with divorce, family law, guardianship with special needs children. And what I found in doing that work is that the two worlds do not like to talk to each other, okay? If you have a guardianship and then you get divorced, the divorce court doesn't know what to do with the guardianship. If you have a divorce and then you need to go over to probate court for a guardianship, they don't know what to do with it. They don't want anything that looks like a divorce in their courts. And so it leaves a lot of my clients sort of in between a rock and a hard space, to say it. So what we're going to talk a little bit about is what happens when you have a situation where either there's an existing guardianship in place over your special needs child, and then mom and dad or partners decide to get divorced. or if there is a divorce and there's a need for a guardianship. And what happens when the child who is subject to a guardianship emancipates for all purposes under Title V of the Family Code? Who has decision-making power? Where do you turn? What do we do in terms of finding support, possession, or access? So that's kind of an overview of what we're talking about. When we are dealing with children in the context of family court, remember that Texas has certain public policy statements, and one of those is that both parents, despite or regardless of their marital situation, will be guaranteed access on a consistent basis to that child. What happens in my world in this specialty is that we have children under, when they're minor children, under a Title V SAPS or suit affecting parent-child relationship, and then they age out. What happens to that underlying rights and duties, periods of possession, access, and child support? Next slide. So remember, however, that everything, both in a guardianship proceeding as well as in a family law proceeding, the overarching guideline for, or the guiding post for the court is best interest. We don't know what that means. It's not defined in the code. If it walks like a duck, quacks like a duck, then maybe it is a duck. I don't know. But the term best interest, you'll hear a lot, both in probate world, even for an adult disabled child and or in family court. Next slide. A lot of times lawyers will talk in code and it can get very confusing. Also, I have found that there's a lot of misinformation out on the street. Not a day goes by that someone doesn't say we have joint custody. There is no such thing as joint custody in Texas. There is a thing called joint managing conservatorship, which in the family code delineates what are the rights and duties of both parents at all time and those that may be exclusively one parent's at the exclusion of another. So remember, the term is joint managing conservatorship. You'll also see a lot of things called legal presumptions. Presumptions, equates to all things being equal. Here's where you start. And so we start with certain presumptions that are already presumed by the court, either probate and or family, to be in a child's best interest. Next slide. So when we have a situation where we have a divorce proceeding or a suit affecting parent-child relationship, we may have this overarching nomenclature called joint managing conservatorship. But in 153-132 of the Family Code, we have certain exclusive rights that can be given to a parent. We call them meds, heads, and eds. Selective or invasive surgical, psychiatric, psychological, and education. These are in play until your child turns 18, whether they're subject to a family court jurisdiction or whether you're thinking about which direction to go for my adult disabled child. Just remember, and I see this all the time, and the judges are also confused. Some judges in the family court believe that they have jurisdiction to make decisions over who has the decision-making power for an adult disabled child, conservatorship, and or possession or access. The secret is they don't have jurisdiction, and that's why you need to consider going over to probate court. Next slide. So one of the things that we find is, you can go to the next slide, Allison, thank you. One of the things that we find is that as a presumption exists with regard to conservatorship, there are also presumptions that are out there with regard to possession or access. Again, when you look at the family code and the definition of child for the purposes of Title V, a child is under the age of 18 or otherwise not emancipated, but for child support. Okay. However, under 154-309, they snuck in a provision for periods of possession or access for an adult disabled child. Next slide, and we'll talk about that in just a few minutes. All right. So remember again, as with conservatorship, the presumptions, all things being equal, can be rebutted if the particular facts of a situation warrant that. The burden of proof would be whether you have a minor child subject to a family court, or you have an adult disabled child subject to a family court, whether or not the presumption of a standard possession order would be in the child's best interest or the emancipated adult best interest. There is a provision in 154-309 that gives a child who is subject to a guardianship and or a possession calendar, if they are competent for the purposes of declining access or possession to the other parent, then they can exercise that preference. That is a nuance um, in under 154-309. Okay.
So Trey, I wanna
Yeah,
ask you a question.
sure.
In the intersection of divorce and
Yeah.
guardianship, and so you talked about there's really not joint custody or whatever, in Texas. So if we have a child that's turning 18, it's a divorce situation. One parent's in the state of Texas, the other parent is out of state, but not a bad parent, whatever. One parent, the kid pretty clearly needs guardianship, but one parent out of state is against this. Um, and I know that there's forms and the doctors sign off on that kind of thing. What about joint guardianship? Is there a such thing as joint guardianship with a divorced parent that lives out of state? Does that even exist? Or what is your suggestion on stuff like
Yeah,
that?
great question. There is a thing called co-guardianship. The Estates Code does allow for parents to be appointed co-guardians of their adult disabled child. If there is a previous joint managing conservatorship in place in a family court and the parents are divorced, but at one time before the child emancipated, there was a joint managing conservatorship, the court can consider both parents as co-guardians. I will tell you, however, from a practical application, in all five of the probate courts here in Harris County, they will not consider the appointment of a co-guardianship of divorced parents. They'll accept an agreement. So in other words, if the divorced parents want to be co-guardians after their marital union is dissolved, and they go to mediation, and in that mediated settlement agreement, there's a provision that they be appointed co-guardians, then unless the court feels that it's not in the child's best interest, they will go ahead and affirm that agreement. And one little caveat here, which is a nuance that a lot of lawyers don't even know, and that is that under the Estates Code, if you have a child subject to a guardianship and you have a mediated settlement agreement, whether out of agreements in the family court or with regard to guardianship, the probate judge has the right to set aside that mediated settlement agreement. That is totally different than the way we operate in family court. So when you have a situation where you have one parent out of state, clearly the guardianship would be established in the county where the proposed ward resides. The court could consider the appointment. From a practical consideration, they're reluctant to do that. I hope that answered the question.
Yes, and then in the example of adversarial divorces where the people that are getting divorced clearly cannot, they're not parenting well together or apart, however that's working, it's unlikely that a court is going to appoint co-guardians in an example of adversarial relationship.
That is very true. Yeah, and the probate judges are great. This is not a criticism, but they sort of, the hair on the back of their neck raises if they sense anything like a divorce proceeding in a guardianship proceeding. So they want you to keep your fight, quote unquote, in the family court and not in probate court. So there are contested guardianships. You have a right to trial by jury on a guardianship issue. So if mom and dad both want to be the sole guardian of the person or the guardian of the estate of the proposed ward, you have a right to your day in court. But from a practical application, the courts will not on their own appoint divorced parents as co-guardians.
Okay, a couple things in the chat box. What about siblings if parents are deceased? Could siblings be a successor guardian? You could appoint successor guardians upon your incapacitation or death. Is that correct?
Yes, like in Family Code 102, there are provisions for standing and priority for the appointment of a guardian of the person. And after parents, siblings are next in line for the court to consider. So yes, you could have mom as the sole guardian of the person, but the successor guardian designated by that individual could be a sibling. Yes.
Okay, got it. So one question that we had today, and I just wanted to mention this, any advice that you would give to a parent who cannot afford to pay for a guardianship? So what I would like to say is that whether you're attending from, I mean, we're mainly talking about Texas and Texas code here and this kind of stuff today, but we do have people that listen in from all across the United States. Um, Disability Rights is an organization that helps families and may help with guardianship if you are indigent or have low income and resources. Also, what you can do is go to Google and type in legal aid near me, something like that. And then the legal aid offices in your particular county, you should look them up per your county. There are a handful of counties in the state of Texas. I think, I know that Galveston had a grant for free guardianship. You had to live in Galveston County. There are a few other counties, in and around the state that have free guardianship, not any around here per se, like Harris, or Fort Bend or that kind of thing. But so you can look up that way. But there is help out there for low income and low resources, for that. Um, so one person says an appointed guardian by court for many years ago. There's no child support, parental rights terminated. So I think they are the appointed guardian for this family member. Um, it was not really a question, but just saying that they were appointed the guardian by the family court, and that was kind of the hierarchy that you were speaking about, like of probably. Um,
Well, I do want to jump in here.
sure.
The family court would not have appointed a guardian. That is solely within the jurisdiction of the probate court. So they probably mean that they were a joint managing conservator with the exclusive right to determine the primary residence or a sole managing conservatorship. But those are words of art. And, we're wordsmiths as lawyers. So I just want to be clear that uh, in that context, there would not have been a guardian appointed over the child. And again, like I was referencing before, once the child emancipates, then all of that conservatorship language is void as a matter of law. That's why you have to consider either alternatives to guardianship or a formal guardianship proceeding. So didn't mean to interrupt, but
Oh, no, no, this is good. Can I go to probate court without a lawyer to to request his guardianship be lowered or removed since I care for her 95%? Basically, I think it's basically saying, I think this is from an ex-spouse or the other parent, asking for the other parent's rights to be reduced or removed since they're providing, the care for said
well,
person.
if there's a co-guardianship in place between parents, and there has been basically a material and substantial change in either the ward's life or a parent's life, then you can petition the court to modify the guardianship. So I think that's what they're trying to ask. Now, if a parent's rights were terminated, then there is a general provision that says that anyone who is interested in the potential ward could make application for guardianship of the person, but if their rights were terminated as a parent, then they don't have parental standing, right? So they would be under the lower rung of anyone else after we've gone through all of these other relationships or categories to be. And you have to be a person of good moral character. You cannot have a conflict with the potential ward, financial, or in the case of some type of contested child support issue. A lot of times we find ourselves in my office, advocating for child support for an adult disabled child. and the method in which that child support has to be paid, so not to jeopardize SSI or Medicaid. But we end up being able to disqualify a potential co-applicant because they have a financial interest adverse to the potential ward. So didn't want to go down a rabbit hole there, but
But I do want to talk about this because there's a few
yeah.
things. There's so many things that are running through my mind, and I know Mary Ann's too here. So child support continuing on post age 18 is common. We see that commonly in the state of Texas for an individual with a disability, and it's not 100% or a slam dunk. But having said that, I would just like to interject that I think it's important if you find yourself in a divorce situation or potentially going down that highway. I think it is important whether you work with Trey Yates or someone like Trey Yates that is specifically nuanced on divorce and divorces with individuals with disabilities. It's important because it's important that we get things right, and it's cheaper on the front end as opposed to doing it on the back end. So we do suggest that you do work with a professional. So there was a couple of questions on that, so I guess I would just say professional services. So whether you're seeking legal services and you're seeking, you need a will and you need a special needs trust, you need guardianship, we want you to work with an attorney that's specifically nuanced on, in those things. Same thing if you're, looking at divorce or kind of going down the divorce highway. Not all attorneys are created equally. Many attorneys have not done divorces that are connected with special needs, and our loved ones have care needs and could have care needs for the rest of their life. And so the planning that goes into that and the child support, the calculations of those child support, it's outside of the 9 dots, right? And that's why you want to work with a specialist on that. So there may be people on here that you have a special needs child, you went through a divorce, the divorce is done, it's already done, child support stops at 18. Those are all reasons why you may want to consult with somebody in the future that is nuanced in that. Trey, could you chime in on that?
Yeah, if we could flip on over to slide 15, Allison.
Tell me
Um,
when to stop.
oh, okay. Keep going. Keep going. Keep going. Okay, right there. Whoop, back one. Yeah, one back. So that's a great opening for me to say just a few issues on this. And I review an awful lot of divorce decrees. I wasn't part of the divorce proceeding, but a parent is now wanting to modify the suit affecting parent-child relationship within the context of the divorce. One of the things that, and I absolutely agree with Allison, if you can get a disability finding under 154.302 at the time you get a divorce, even if the child is under the age of 18, you're going to save yourself a lot of time and money when they do emancipate, okay? Number two, the way that child support, the amount of child support is figured is different than if a child is a minor. When you have an adult disabled child, this is the seminal case. It was my case that was up on the 14th Court of Appeals. It's still good law, even though it's a little old now. And the 14th Court of Appeals gave us the proper analysis for the trial court in coming up with the amount of child support. And those are contained under 154.306. There are still special considerations. You still have the presumption of guideline child support, but it gives the court an opportunity to consider the future needs of the child, where when we're doing it in a traditional minor role, a child that's a minor, you can only talk about their present needs. And also the net resources available to both mom and dad or both parents is relevant as opposed to just who would be the obligor paying child support. And then finally, you cannot receive child support as a parent on behalf of your adult disabled child directly. You must go to individuals like Allison to put together what we call a first party Medicaid payback trust, because if you don't, and the parent who receives the child support receives it as trustee of that trust, And you want to make sure that that language is in your divorce decree or the SAPSR, that once they turn 18, if child support is ordered indefinitely, then you want to make provisions that once they turn 18, and also the Office of the Attorney General does not offer services for adult children, okay? They'll still receive child support and disperse it, but they don't have enforcement capacity or jurisdiction. So you want to make sure that it's put into a first party Medicaid payback trust, which is totally different than a supplemental needs trust, which is the way that you do your estate planning for the potential ward.
So I
So,
just want to talk about that for a
yeah,
second because it's
yeah.
important. And guys, we're not going to get to everything today, as I mentioned earlier, but to Trey's point, this is exactly why you want to work with an attorney that is specifically nuanced in child support matters for people with disabilities, because he's so right. It does need to go to a first party. Child support does need to be redirected to a first party special needs trust. And the reason why is we want to preserve their eligibility for state and federally funded programs, Medicaid, SSI, for instance. So that is the reasoning behind that. So when we see other attorneys that aren't nuanced in special needs, we see no provision for that. And then you got to go back to the well, spend more money is basically how that happens. But I also wanted to draw lines of what we do, what an estate planning attorney does, and what Trey does, because Trey is focused on family law, special needs, divorce, and other things of that nature. Then we've got estate planning attorneys that are going to do the guardianship, the special needs trust, the wills, power of attorney, healthcare power of attorney, supported decision-making agreements. And then we're the money. So I say the legal documents, the legal proceedings, that's going to be somebody like Trey. And then as far as your legal documents and professional documents, that's going to be more of your estate planning attorney. And we do have specific recommendations. We make recommendations all the time to attorneys that are specifically nuanced in this and that can help you, because again, we suggest that this is not a do-it-yourself project. You do need help with this, and you do want to work with specialized help when you do this. It is critically important. And I know we see things. I know the estate planning attorneys that we work with see things, and Trey, you see things all the time that need to be undone because they didn't work with professionals that were nuanced with for people with disabilities. So I think that is a message I want to make clear. We did have a question, Trey, that I want to hit on.
Yeah.
It said, can I go to probate court without a lawyer to request guard? No, I'm sorry. Basically, can I do guardianship on my own? Is basically what I want to know. Can I do this without an attorney?
Well, the stakes are so high, you would ask yourself why. Cost may be a factor. Yes, the courts will allow pro se litigants in guardianship proceedings. I will tell you that the probate courts are rule enforcers. You cannot go from point A to point C unless you also go through B. So trying to, it's the right thing to do, best interest. The courts are very protective. The probate courts are very protective of the wards that they have jurisdiction over. You're going to anticipate an ad litem appointed for the potential ward, maybe a guardian ad litem if there's a contested issue. They all charge. They're attorneys appointed by the court. You're going to have your physician letter in order. So it gets pretty complicated. And because the stakes are so high, right? Why would you entertain that?
I
But
would I would
short
strongly
answer,
advise
yeah,
against
short
it going,
answer is yes, you can do it on your own, but
but you shouldn't.
you
Um,
shouldn't. You wouldn't, I drive a nice fancy car, but you don't want me repairing it, right?
right.
I can tell you that. So,
Stick to what you know.
I can't do what Dr. Montfort does. I can't do what Ann Hughes. I know I'm smart enough to know to stay in my own lane and solicit their input and yours as well, Allison. You just don't want me doing brain surgery on your child. It's not advised. Sorry.
So I just want to say that we have entire webinars about guardianship, guardianship of the person, guardianship of the estate. We commonly don't see guardianship of the estate in Texas. You absolutely can have it, but there's even thresholds, and I think that threshold's up to 20,000 right now. So while some states like California, when they do guardianship or conservatorship, they do guardianship of the person and guardianship of the estate. Some states do it differently, but Texas generally doesn't do that. So if you think, hey, I've got guardianship of the person and my attorney messed up because I don't have guardianship of the estate, and you're in Texas, your attorney probably did not mess up. It's probably fine in this state. So I want to invite you guys to the Consolidated Planning Group YouTube channel. We've got lots and lots of webinars on that very specific topic where they'll take a deeper dive and talk about talking about the guardian ad litem and talking about the certificate that gets signed by a doctor and things like that. And I think we do have some other things on that today. Where do you want me to go from a slide perspective, Trey?
Let's just go to the next slide about support. Because again, it's that intersection. You have courts, the family courts set the amount of child support, by the way. Um, the probate courts are very reluctant to weigh in on the issue of child support. So you're going to find yourself in a situation where you may have to go back to the court that granted the divorce on a motion to modify. But you want to make sure that the court knows, the family court knows, and my experience has been, even though everyone here on the screen and everyone listening, their world is special needs. These judges don't see these cases all that often. And so I find myself not only as an advocate, but also trying to gently educate them as best they can. But you want to just make sure that the amount of child support, you can think outside the box under 154.306. And that's just all I want to stress here. And a lot of times family law attorneys will use something called the Texas Family Practice Manual form language. That language itself is not geared for the nuance of a child with special needs. So just be very careful about that. And the next slide, if you could. One of the things that I find is that I read these decrees and there's a definition for what are healthcare expenses that will be shared by the parties, either usually uninsured. But a lot of times we have kids with special needs that have ABA therapy, that have special equine therapies. Who's going to pay for that post-divorce when there's no community estate, right? Tutoring, speech therapy, nutrition is a big cost. And so we try to push the limit as best we can to advocate either by agreement or by court order that we expand the definition of what are healthcare expenses as it relates to a child with special needs. So let me move quickly over because I know we've got two talented people there. If we could go, Allison, to slide 22, which says, let's see, keep going, keep going. Oh, one back, sorry, my fault. You're a fast clicker there. Oh, next one. Oh, no, next one. Sorry. Going backwards. Sorry. Okay, that one right there. I just want to say, I see this a lot. So mom and dad, parents get divorced. They have in place a parenting plan that they have operated under for several years. Then the child emancipates. And remember, whether they're subject to a guardianship or not, everything in that divorce decree that has to do with your child, but for child support, is no longer valid as a matter of law. Okay, they are emancipated once they turn 18, not when they turn 18 or when they graduate from high school, but when they turn 18. And so you then have to go to the estates code. And when you have a guardianship, then we have these general powers and duties of the guardian of the person. And this is directly out of the statute. It looks very similar to those rights and duties that you may have had in your divorce decree or SAPSR. But you'll notice that when we have a situation where we have co-guardians of the person, there is no delineation as to between the co-guardians, like a joint managing conservatorship, as to which of the co-guardians has the right to establish where the ward lives, or duty to support protect, provide clothing, power to consent. So these are forward-thinking problems that may arise that if you can address them while you're going through the divorce or while you are deciding if you want to do a co-guardianship with a person, again, you can see where a dispute could arise. And one of the reasons why, from a practical consideration, the probate courts will pass on a lot of those issues, okay? They encourage family settlement agreements. It's throughout the estates code, just like we have mediation in family court. So the magic, the nuance can happen in the context of mediation. Again, the probate courts are somewhat limited in their creativity, as are those judges that are in family court. So I just wanted to point that out, that there's a similarity, but they're not the same. Let's see, what else? Oh, Allison, if you could move forward a few slides. Next one. Next one. Next one. Next one. Next one. Okay. This is a unique provision in the estates code as it pertains to guardianship. So you have probate courts, which are county courts, and you have family courts, which are district courts. They don't like to talk to each other, but sometimes they have to, given the circumstances. So be aware of the fact that you could have a proceeding in family court, a simultaneous proceeding in probate court on a guardianship, but the probate court has the jurisdiction to grab the family case and consolidate it into the guardianship. It's not true on the reverse. The family court does have no jurisdiction over anything that has to do with a guardianship, okay? And so just be aware of the fact you may find yourself in a situation where it's cost effective once you have a settlement or once there's been litigation to ask yourself, should I have that family court case consolidated into the guardianship case? Because without it, you've got simultaneous proceedings and you may have to hire different lawyers because they may not have the ability to operate in both jurisdictions. So I just wanted to make sure that we touched on that very quickly.
Yes, and
Yeah.
Trey, I'm glad that you made that clear, and I think that's what I was getting at earlier is that you end up having different lawyers for different things. Like, again, if you're going through a divorce and if you need to set up a special needs trust or a guardianship, that's not including what he just talked about here. So it can get expensive quickly. But just knowing, because I get calls all the time of, can you set up my special needs trust? And we don't do that. We're the money, right? And I'm sure you get calls, can you set up the special needs trust? And that's not exactly what you do. So I think understanding the intersection of kind of the lines of the different practices. And the thing is, I know it's annoying when you're, filling out paying your legal bills. But you don't want everybody intersected doing the same thing. The lines are clear for a reason, and that's for your best interest as the consumer. So I just want to make that clear.
I absolutely concur 100% with that one. I know to stay in my lane, and any lawyer that would say that they litigate the issue of conservatorship and or guardianship, and they can also do the trust, I'm not so sure that I would be working with them, quite frankly. So if we could skip over, because I did want to touch about the burden of proof when we have, here we go, right there. So I'm surprised continually at how, even though the child may have received services since they were 2 or 3, they're on the Medicaid waiver list, they're receiving class or other services, when the idea that one parent has to pay child support to the other parent indefinitely, right? Suddenly we have selective memory over the extent of the disability of the potential of the ward or of the child subject to a 154, 302, 306, 309 proceeding. And so I routinely, when we have a situation where there seems to be some pullback by one parent as to the extent of the involvement, and you know, under 154, 302, you have to establish the child has a disability that was known to have existed or existed prior to their 18th birthday, and that they are incapable of self-support. And as Allison brought up in her introductory remarks, you know, what does that mean in terms of self-support, right? They may sack groceries at Kroger's, but once they get their paycheck, they don't have the capacity to know what to do with that paycheck, right? Or that, you know, you put it in a bank account and you write a check for your rent. And so my experience has been that if you're involved in a situation where you believe that there's going to be a contest of one around a disability finding under Title V, you need to be on top of it. You need to gather up all the medical history that you can. You need to then have someone put together a life care plan where they are able to reference the various otherwise inadmissible hearsay that's contained in those medical records, and or hire someone to do a forensic evaluation. Because I believe that the burden of proof, if there's a contest under that disability finding, will require medical testimony. Okay. So I just want to make that point clear. And you can't just hand the judge the FIE or the assessment that was done in you know the school and expect the judge to be able to read it, because the other side's going to object as to hearsay. So we use the forensic experts a lot as a practical tip to just get in a lot of otherwise inadmissible hearsay. So the burden of proof, if contested, in my opinion and experience has been, you're going to have to get medical testimony.
I think that this is important, and also some of that, you know, there are some organizations, and I know that Marianne has referred them in the past, where they will, like, they are doctors or RNs or whatever that that kind of do that. They're harder to find. They used to be easier to find. I found that they are harder to find. But from a financial perspective, I just wanted to chime in here that this is separate. These are expert witnesses that you're paying. So if you're counting up the dollars as it relates to your divorce, these are separate people that you're hiring to do this work. It's outside of what, you know, your divorce attorney is charging or et cetera. So I just wanted to make that clear.
And with that, Allison, I'm going to be quiet. Turn it over to Marianne and or Dr. Montfort.
Trey, you've given us a lot of information and it is very valuable. One question that we did have,
Sure.
I know that we have people here, some people here that are getting divorced, some people are already divorced, and maybe their documents need to be evaluated, maybe their child support needs to be reevaluated. I don't know. Um, are there a particular handful of counties that you work in? I know that your office is in the greater Houston area, but are there other outside counties outside of Harris that you presently work in?
Yes, we routinely practice, a majority of our practice is in Harris County, but Fort Bend, Montgomery, and Galveston. Sometimes Brazoria County. When you go into these smaller jurisdictions and you're the big city attorney, you have to kind of make sure that either you have a local contact, which is always helpful, or you know, just know that each and every county has different rules. That's the big thing. They're not all the same. Here in Harris County, we've got 10 family courts, and they rarely can get together on one page about anything either. But just be aware of the fact that each one of those counties has their own special rules. So you do want to work with lawyers that are familiar with those courts. So,
For sure. We've put Trey's contact information in the chat box. I'll put it out there again. Everybody's going to get a copy of today's slides, and it's going to have Trey's contact information in there as well. And I do want to mention, and there is a slide for this as well. There is an event that's coming up on Saturday at 8:30. I think it's 8:30 to 2:30. Just talk about that really quick, and then we're going
sure.
to come back to Marianne and Dr. Montfort.
Yeah, I appreciate that. Yeah, I started a separate 401 501(c)(3) called the Guide to Good Divorce. It's for women only. We hold these seminars at the St. Regis here in Harris County. We work on the hard sciences in the morning, the legal part of a divorce or a suit affecting parent-child relationship, and then the financial part. And then we transition in the afternoon to life skills. The caretaker needs to be cared for, meditation, gratitude work. And it gives you an opportunity for those that attend to be able to network with other women that are going through the same thing. You know, women share differently than guys do in a public forum. Guys, when we raise our hands with a question, we think we already know the answer, right? Women, on the other hand, my experience has been is that you're more open to exchanging ideas and showing your vulnerability. So I watch people make connections. So it's a nominal charge. The website is called The Guide to Good Divorce. There is no solicitation. There is no follow-up. We don't capture your information. We don't tag you. We don't do anything like that. It's just our gift back to the community that has been so gracious to us. And on Saturday, you're going to be able to see Dr. Montfort and Mary Ann present in a much broader fashion. We'll have other experts, but it's a really safe place to be. And I would encourage you to, some of your listeners here, viewers, to just jump on the website. There's a lot of information on the website. So thank you, Allison. It's really, the work has integrity, and I'm so excited that I've been able to gather the experts like Dr. Montfort and Ann Hughes to impart their wisdom to us. So thank you.
For sure. And guys, there is going to be a slide in this presentation that talks about the thing on Saturday, and it'll give you all the information. All right, Mary Ann, you're no stranger to CPG. We've done lots of webinars with you in the past, and we see you in person at all the special needs fairs, and she's very active in the community as well. So let's talk a little bit about the special needs co-parenting, and she is the founder of Special Needs Family Transition, certified special needs divorce coach, mediator, parenting coordinator, pre-mediation divorce coach. She doesn't do what Trey does, and Trey doesn't do what Mary Ann does, but Mary Ann has a lot of experience with this, and it is our pleasure to refer families over to Mary Ann. So I'm going to let you take that away, Mary Ann. And I should say that Mary Ann is a proud parent to 2 kids with disabilities herself. So she eats, sleeps, and breathes this. She knows it backwards and forwards, and it's always a pleasure to work with you, Mary Ann.
Yeah, I appreciate that, Allison. Well, it was a pleasure to collaborate with you. And as you mentioned, I went through this process, and out of what I learned through this, I decided to help others who are going through divorce and co-parenting when they have a child with a disability. But my focus is putting the children first and helping the parents think about that as they're making decisions. So hopefully we won't have to have all these litigated issues and so on. We want to do things, hopefully think about it in a broader sense so that we're thinking about the kids as we make these decisions, and hopefully come up with a better result for everybody at the end of the process. But when thinking about the children, we want to make sure that we don't put them in the middle of conflict. Some people think because a child maybe is nonverbal, they're not understanding or paying attention to what we're saying, but that's not the case. So we have to be really careful not to have a child feel like they have to take sides, but also don't talk negatively about the child or the situation in front of them, or I should say about the spouse. And so as much as we can, you may not be getting along right now during the divorce, but we want to do what we can so that we are encouraging a positive relationship during the difficult times as well as afterwards, because one day this divorce will end and you're going to have to co-parent. That's going to go on for the rest of that child's life, especially if they have a disability. So it's not like it's going to just end at 18. And there are resources to help you through that process. People like Dr. Montfort and other mental health professionals and other supports to help families do that transition. I'm actually right now this week starting a new training for a co-parenting specialist training to kind of focus more on that area as well. Normally I work with one parent as a coach, But like you said, I have different certifications and different things that I've done where I can work with both parents. And that's the goal, to make sure that we're all going to be on the same page and making good decisions for the benefit of our child.
And sometimes it is impossible. I mean, I know that Trey knows of the adversarial situations and things like that, and sometimes it's not possible. But the more that we can get along, the cheaper it is, for sure. And honestly, I think I can, look back. I mean, people are going to get married. People are, our kids are going to have babies. Our kids are going to get married. There might be good times, bad times, celebrations, graduations, other things like that, that paths are going to cross again, even if you don't want them to. And so but when you're in the heat of the middle of everything, emotions are really running high, and it is so hard.
Right.
But I am a fan. It's better for the kids when people can get along. It is so much more effective for the kids. So I love that you put that on there, Marianne.
Right, right. And so that's what exactly it is, a very emotional process for sure. And like you said, it can kind of cost a lot of money and there's all these experts involved. And so my role is to help people go from the emotion of divorce to the business of divorce. So look at it as a business transaction. And as Trey said, we all stay in our own lanes, but I'm there to help them maybe prepare, get ready, be organized, uh, for their meetings with their attorney and other professionals like yourself, so that they're focused during that time on what that needs to be discussed during those meetings, and that way they can appreciate and really listen to what that person is guiding them to do. But in terms of how do we support kids during divorce, we don't want to just all of a sudden say, hey, this is your new routine. We want to kind of ease them into that. If you know it's coming, maybe have each parent, the parent who hasn't been as involved, maybe have them become more involved and learn how that child needs to be taken care of, whether it's medically, whether it's emotionally, or whatever it might be. And then maybe increase the time that the child may spend at the new residence if somebody's already moved out or will be doing that in terms of possession plans and so on. So we want to do it slowly, especially kids with autism. They thrive on routine and like predictability. So we want to share that with them, to say, okay, well, here's maybe a calendar, visual calendar about where you're going to be when, so they can maybe reduce their anxiety around that. And also, one thing I did for my kids was create a social story to explain to them what they could expect, how our family was changing, but it's still, we're still there loving you as a child, but it's going to look different in terms of maybe having to go from home to home. So we want to do this in a positive way so that the child, once again, doesn't feel like they have to take sides. Sometimes kids feel like they're part mom and part dad, and if they feel one parent is seen in a negative light, then they reflect that upon themselves. So we don't want that to happen. But part of this whole process is making sure that we're on the same page about the child's disability, different therapies they may need, and what we want for the future. Because as you all have mentioned before during the session, that's where the disagreements come in, and it's part of the what can make this process more complicated. And these are just some resources I wanted to share. You mentioned about the Guide to Good Divorce seminar. There's a link there if people want to learn more and sign up. I definitely recommend it just to have more information about the legal aspect. We talked a lot today about the guardianship aspects, but there's so much to know about divorce and how that can impact you. So it's a great way to learn that, as well as kind of being mentally prepared for the whole process. Part of my framework that I call is RISE, where I have my top tips for families as they're going through this process. And so I have a little mini course I put together. You're welcome to look at that if you choose. I also have a lot of podcasts that I've been on, the ones from Consolidated Planning Group and other things that I've done, that I put on a playlist on my Special Family Transitions YouTube channel, which is a great way to get information if you're going through this, for encouragement and all different areas that may affect you personally as well as your children. And then I'm excited to be collaborating with an author to tailor a special needs a divorce book for autistic kids. So we're excited about that. And then Allison's going to be one of our presenters. I'm having I'm a part of a new organization I just created called Divorce with Special Needs Children, where we are bringing together experts in special needs divorce and who can support you. And so we're going to have a free summit for people to participate and to join us to watch it. And I'll share more details on that. So definitely follow me. And the next slide has my contact information and my Facebook, where you can follow me to learn about upcoming events and how I can help.
And I would just like to say that Mary Ann is a wealth of information, in this little page of links and stuff like that. That is just the beginning of her knowledge of other resources that might be of assistance to you. So definitely reach out to Mary Ann. She's learned a lot along the way and can definitely help you in this journey. And sometimes that help is just kind of calming your fears. There is a lot of anxiety around this process of divorce and special needs and all this other moving parts and court hearings and judges and all this stuff. It's stressful. So so Mary Ann's got some good guidance on that, and I know you do too as well, Natalie. So Natalie, tell us a little bit about you. Thank you for being here. This is a first timer for us with Dr. Natalie, so we are glad that you are here. So tell us a little bit more about you and your practice. Oh, you're on mute.
There we go. All right. Well, thank you for having me. I'm so glad to be here and hopefully add to the conversation. So I am a licensed clinical psychologist in private practice here in Houston. I've been in private practice since the COVID pandemic, but really in this field since about 2002. So almost my entire time through even my education was in this field. And also my husband does the same work. We met several jobs ago, and we're parents to a special needs young adult who we didn't know had special needs until he came to our house. He's adopted. All of our boys are adopted at older ages with a variety of needs. So we have done this for work for years and years, and we also do it as parents now, much to our surprise and enjoyment. So today we're going to just talk briefly about how do you know if you actually need guardianship, just sort of backing up from this process. On the child's 18th birthday, you're going to lose legal authority. So people are often surprised at what that looks like. It means there's some doctor's offices who aren't even going to let you schedule. Although HIPAA does allow others to schedule for an individual, there's some doctor's offices that are going to have policies that they just won't even speak with you for scheduling purposes, let alone medical records. You can't request records. Your child, who's now a young adult, will have to sign their own IEP and ARD meetings. Those are the processes that happen at the school. If you don't have anything in place at the time that happens, they can live wherever they want. Also in a time of crisis or emergency, you will have limited ability to help, and your young person may be at risk of exploitation or making unsafe choices with little recourse. So next slide. Now, I'm not going to read all these questions to you, so they're going to be sent out in the slides that you can take a look and see just some things for you to consider. But what I will tell you, the kinds of questions that I encourage families to ask are really practical. Would your young person give money to a homeless person? How much? How do they know when to stop? I've had individuals tell me, absolutely. Well, how much would you give? Everything in my wallet. Would they give money to a friend online, someone they've never met in person? Usually those initial asks are about $5, right? So it doesn't sound like grooming or manipulation. Can they listen, understand, and follow up on a doctor's recommendation? And most importantly, would they consent to a painful medical procedure? What about revoking consent for a painful medical procedure? If they've retained their own rights and they say, no, stop, the doctor's obligated to stop, right? Unless there's some special circumstances. So next slide. We're looking at things like practical knowledge. How often do you wash a bath towel? What about bed sheets? Can your young person select their own food? And then I like to add, and live to tell about it. Do they eat things that they're allowed to eat that, aren't prohibited because of allergies or special nutritional needs? Can they manage that? And there is some help and support for these things, even if they retain their own right. So I'm not just pushing for guardianship. Like at the beginning of the presentation, you heard we really want to do what's in the best interest of the young person. But these are some questions to help guide your decision.
I think these questions are great questions. As one thing, as presenters today, we were talking about is, in Texas, the least restrictive, most appropriate, and sometimes that has lent itself to least restrictive and ignored the most appropriate. And some of these questions that you've got on here are, getting to what is most appropriate. And
Right.
I always like to tell people, because the word guardianship is a little bit scary for a lot of people and what they're, signing up for or taking away and that kind of thing. And I just want to tell people that you don't have to know what you need when you go sit down with an estate planning attorney to talk to them about guardianship. They are going to ask questions. They're going to ask questions of your child. They're going to take a deeper dive, and they're charged with that least restrictive, most appropriate. But these are some of the types of questions that you may be asked, and then together they'll help guide you in the right direction that is most appropriate for your child. What's most appropriate for your child may not be most appropriate for your neighbor's child that has the same diagnosis but other extenuating circumstances. So it's just really important to know that the right answer is not found around the water cooler or even at the special needs resource fair moms group or whatever, because it is very individualized. And so
That's right.
I think that, and that, the healthcare, being able to manage healthcare and stuff like that, Dr. Natalie, I want to I want to hit on, I know we're out of time for today, and so we're going to send the slides with the case examples, but I want you to give us, the three big takeaways that you want to make sure that we take away today. And then also, Dr. Montfort, we would really like to schedule an additional webinar with you to take a deeper dive into these topics, because I know you know a lot about this. So give us our three takeaways on that.
Sure, sure. Well, I would just jump to that very last slide right before this one and tell you, a psychological evaluation can also help with this process. It can give you, objective data that's in context with what you know about the young person, how they perform on assessment measures, and another opinion on what they may need, what's their level of support that they need, based on the assessment. So like you just heard, it does differ person to person, and every family's plan is individual and individualized. So definitely seeking providers who can help you and support you through this process, like you've heard from today, and an evaluation and a psychologist is one piece of that. And my understanding is in Texas, psychologists can again sign guardianship paperwork if that is something you're pursuing for the courts. For a little bit, they took that away from us and said medical doctors only, but because so much of it revolves around the type of testing that we do, we can help you with that process as well.
I think that neuropsych testing is important and is not only helpful for the guardianship process, but there can be educational components added to that that are helpful, that'll get a refresh on the IQ testing. And a lot of times that testing also provides recommendations of where do I go from here? Now I got all these results. How do we close the gap? How do we get better? What type of therapy might be helpful? So if you haven't done that ever, or you've not done it in a very long time, it might be a good time to do that. I am a big fan, and I think it gives a lot of data points that ultimately as parents we want to help our kids, right? Whether they're adult kids or kids, whatever. And it gives us a lot more information to be able to close the gap on some of those things. This slide here, again, everybody's going to get it. This is the family law for special needs families, the guide to good divorce, taking place this coming Saturday, September 13th, 8:30 to 2 at the St. Regis Hotel on North Post Oak Lane in Houston. So check out this website. You can certainly go to that. And we've got the contact information for Mary Ann, Trey, and Natalie. So you've heard from all of them. You'll get all of that. And then we'll have a link for our upcoming webinars that you can register for. Anytime you register for the webinar, you're going to get a copy of the slides and the link to the recording after the fact. We always offer free personalized consultations at CPG. If you had questions that we didn't answer today, we will connect with you. We're always happy to have a free personalized consultation. And again, you can reach out to Trey, Mary Ann, and Dr. Montfort as well. So it has certainly been my pleasure being here with all of you today. Thank you guys. We had a lot of information to pack in a short period of time, and we will definitely do this again. So thanks so much and have a great one.
Thank you, Allison. You too.
Bye now.
Thank you.
Bye-bye.